It was a dark and stormy night. The sea crashed against the rocks down by the shore. Spray hammered against the window of the small cabin. Suddenly, there was a knock at the door. The door swung open, and there, lying on the ground, was the body of a gray tabby cat. No one was visible amongst the rain-drenched gloom.
I wonder if I'm infringing someone's copyright by writing a mystery novel about a cat. Or starting the story in a remote New England cabin. Or beginning it with, "It was a dark and stormy night." Surely I've heard that somewhere before. Or am I just imagining things? Today, we're going to dig into the problem faced by our aspiring author. Is there copyright in the concept of a mystery novel? What about the idea of writing a mystery novel about a cat? Setting the story in a remote New England cabin? Before we talk about those ideas, though, let's start with
It was a dark and stormy night.
In Feist versus Rural, you learned how facts are not protectable by copyright. I want to really emphasize that point. Facts aren't protectable by copyright. That was one major takeaway from Feist versus Rural. We often call this distinction the fact-expression dichotomy. The use of dichotomy here suggests that if something is a fact, it's not creative expression. And if it's creative expression, it's not a fact. And if something is a fact, it's not protectable by copyright, either because it wasn't independently created or because it lacks a modicum of creativity. That's because under 17 U.S.C. Section 102A, and the common understanding of the Patent and Copyright Clause of the U.S. Constitution, something that isn't an original work of authorship cannot be protected by copyright. But here we have a fictional story, so the weather outside isn't really a fact, it's made up. However, you also learned from reading Feist versus Rural and our in-class discussion that in order for creative expression to be protectable by copyright, it needs to be an original work of authorship. And to be original, the work must be independently created and have a modicum of creativity. We can look at our author's opening phrase, "It was a dark and stormy night," from two directions. First, might our author have copyright in the phrase as an original work of authorship that our author created? The answer is, of course not. Our author didn't come up with the phrase, "It was a dark and stormy night." The phrase is ubiquitous. It's about as well-known a phrase as there can be. So our author can't have copyright in that phrase. What about looking at it from the other direction? The author's use of the phrase as copyright infringement of somebody else. Could our author be infringing on the copyright of another? The answer again is no. The phrase originally came from the opening of an 1830 novel by Edward Bulwer Lytton, a work in which the copyright has long since lapsed. And so to the extent it was ever protected by copyright, it no longer is. Now it's part of the public domain. But what if the copyright in Bulwer Lytton's novel hadn't expired a long time ago? Then the answer is maybe, but still probably not. It could have that modicum of creativity, but then again, maybe not. And whether there's infringement liability requires a second analysis. From this examination of the author's use of the phrase, "It was a dark and stormy night," we can draw two main points. First, always assess copyright from both angles. Does the author hold copyright in their own expression? And separately, could someone else have existing copyright rights in the material the author is using? Second, when determining if copyright protection exists for creative work, ask whether the work is an original work of authorship, meaning it must be independently created and possess at least a minimal degree of creativity. Now let's turn to the other problem that our author presents. What about copyright in ideas? There are a few different levels at which we might analyze this in our scenario. First, there's the idea of a mystery novel. What do you think? Do you think the idea of a mystery novel is protectable by copyright? Of course not. That idea wasn't independently created by our author, and the idea of a mystery novel lacks a modicum of creativity. Other people have written mystery novels before. Think of a bookstore. There are tons of mystery novels in a bookstore. No one owns the idea of a mystery novel. But what if it turned out that this mystery novel involved an intergalactic war between giant space cats and 6-foot-tall telepathic hamsters? What do you think? Is that idea protected by copyright? For the sake of discussion, let's assume that this idea was both independently created and had a modicum of creativity. Is it still protected by copyright? To help you analyze this hypothetical, you're first going to read a case about a much less riveting idea, a method of accounting and the corresponding accounting forms. The case you'll read in this unit is Baker versus Selden, and the work involved was Selden's condensed ledger, or bookkeeping simplified. A copy of this book is available on the coursebook site. It's not that long, and most of it consists of examples of the accounting ledgers and blank forms. Here are a few pictures from the book. As you read Baker versus Selden, be thinking about what's going on here. What was Selden claiming copyright in? What did Baker actually copy? Before you read the case, I want to clue you in on the background statute. Remember, copyright law is statutory, so knowing which statute is applicable in a given case can be very important. The Supreme Court decided Baker versus Selden in 1880, and the copyright statute that Selden sued under was different than it looks today. Before you read Baker versus Selden, take a look at the Copyright Act of 1831. You may notice that the statute that applied in that case doesn't include any language distinguishing ideas and expression. At the time of this case, the defendant was raising a question that didn't have a clear statutory answer. What is and isn't protectable by copyright? In Baker versus Selden, the Supreme Court drew the idea-expression dichotomy, but it would take another 97 years until the distinction was added to the copyright statute. Often gaps in legislation are revealed when litigation arises, and it's through court opinions that the new rules are first carved out. From there, the legislation may be updated to reflect the current state of the court's holdings. Baker is a classic example of this phenomenon of litigation paving the way for new statutory law. Baker versus Selden set the ground for the modern rule, 17 U.S.C. section 102b, which codified the idea-expression dichotomy laid out in the case. As you can see, section 102b affirmatively denies copyright protection for ideas, procedures, processes, systems, methodologies, concepts, principles, and discoveries. The statute limits protection even if the creator records something creative in a tangible medium. For example, if an author writes down on a sticky note,
E is equal mc squared,
it doesn't matter that the author wrote it down. It's still an abstract idea and therefore excluded from copyright protection under 17 U.S.C. section 102b.
Thanks, Mr. Author. I can't wait to read the next book after Hamster Harry and the Ninja Kitties of Omicron 5.